Good morning, all. The topic which the organizers given to me is framework on legal framework on disability. If you want me to discuss on the topic of legal framework, I would like to start my introduction by referring to a famous judge of the US Federal Court, David A. Staten, who got retired recently. He was administered by the Clinton administration and he served as a federal court judge for about 30 years. Recently came out with a book, memoir, Vision, Blindness and Justice. In his entire reference in the book, the judge Tattle, he says that he was hiding his disability. Today the Madras School of Social Work students, we went through in the morning about how to reach the unreached, how to serve the poor, how to serve the marginalized, how to serve the weak, and thereby, by serving them, the students can be a guiding star or like shine like a diamond. So that is the purpose, the holistic way of approaching the things in a very better and an efficient way. As I said, if you take Tattle, a person of his caliber who has made a lot of achievements and accomplishment in his life, he doesn't want to disclose the disability. It needs a self introspection as to why he want to avoid or hide his disability. The reason is very simple. He might be perceived by the rest of the society as a person because we judge or assess a person only based on the functional ability. And does it mean that person with a disability to excel in their career, do they have functional disability in the contours of disability? Of course not. A person might be disabled, but it has got nothing to do with your ability. It all depends upon how you effectively function yourself to perform the job or a task that is assigned to you. Like, I'll tell you some case laws. Today we talk about accessibility. Accessibility is the key. Now the same David Tattle, he says 30 years back he was able to educate himself by the assistance of a reader. He used to have a part-time reader, full-time reader. They were doing the full assistance. Thereby he got himself educated. He was able to empower himself, see the rest of the world, analyze the things in a cognitive way. But ever since the technology has transformed, now we are marveling the technology. There is a technological revolution. Today when you see the technological revolution, by having access, you need not have to be dependent upon anyone. You are independent in the sense the technology enables you to read anything. Even a person with visual impairment will not have any difficulty in having any access issue. He can read by himself. To quote an example, a friend of mine who is a visually impaired, a professor in law, is heading a HOD, is a HOD in the department in the law School of Excellence in Ambedkar Law University. He has done his doctorate by name Professor Elumalai. By the by using the laptop, by downloading all the judgments, by the technological revolution, he is able to read. In fact, if a person is born with a disabled, 30 or 40 years back, they used to say that a person cannot play. Why he cannot play? Because he is disabled. A person cannot read. Why? Because the girl is a disabled. Today things have changed where you need to have a purposive and a reasonable accommodation. By referring to this particular thing, David Tattle himself says, today he is in a much better position that without the assistance of any part-time or full-time reader, he is able to read on his own. Thereby, he is able to equip, develop his knowledge. Now, not only that, you need an analytical brain to, in a thematic way, you need to understand what is just, what is wrong, which is quite in a reasonable way. You need to structure your coherent thoughts so that you can be a better able person, albeit having this disability. Now, moving on to the next, I'd like to quote a famous case law, Price versus United Kingdom. In the particular case law, a lady of aged about 21 years old, she was sentenced by a judge, not on criminal grounds. She had some debt. She couldn't clear the debt. Because of the reason, when a question was posed regarding her financial details, she kept silent and refused to divulge any information to the judge. The judge got annoyed and immediately sentenced her on contempt of court for 1 week of imprisonment. After the imprisonment given by the court, the girl was sent to the prison. Before that, she was taken to the local police station. In the police station, and she did not have four, she got all her four limb affected. She could not walk. She can move only with her wheelchair. In the police station, she was not treated properly. A fair amount of dignified treatment, which is inherent to every human being. Because in law, what is to be seen is that everyone is sacrosanct, inalienable, immutable. Every human body should be protected, it should be preserved, it should be worshipped. And if any person assaults A or B assaults you or try to touch you without your consent, it is nothing but a battery in law. It's an offense. So in the police station, she was not treated properly. Then she was taken to the prison. In the prison authorities refused to allow her battery car in the wheelchair. She was having a wheelchair. She said she need to use the battery car. Prison authority said the prison manual did not have a provision for taking the battery inside the prison. As a result, she was denied the complete access. In addition to that, she had a renal failure. Because of her medical complication, she was administered a dose and she was under constant treatment inside the prison. An ignominious incident happened in the sense, even to use her bathroom or access for to use the restroom, it did not have a proper access because it was not designed in such a way to accommodate every individual or every human being. So because of this lack of facility, even the prison authorities had only one female staff, and because of her deteriorating health condition, because she was not given proper food and care, not proper treatment, and some of the male staff accompanied her to the restroom. So she filed a petition against the UK government. The matter went to the European Court of Human Rights, which is one of the most decided contentious case in the global framework of disability rights. Today, if you apply the judgment, if you take Indian conditions, the law says that even a person might be a criminal or inhuman person. He is not supposed to be administered in a bad way, cruel, inhuman, or degrading punishment, which is called as a CID, that is cruel, inhuman, or degrading punishment, should not be inflicted upon any person. Now the lady went and said, you see, because of the lack of proper medical care or facility, even inside the prison, I did not enjoy the right of a human being. As a result, the European Court held that the UK government, in fact, have violated the UN Convention on the Rights of the Person with Disabilities, because every person is an inherent individual. Their dignity should be preserved and protected. If there is an invasion of privacy, or if the rights are infringed, or if the state did not provide any access in the sense access to education, access to healthcare, access to employment, access to recreation, access to sports, and a host of other gamut of rights which a person is supposed to enjoy in this planet like any other human being. You cannot discriminate or disentitle certain right of the differently able on the grounds of differently able. Now, this is with respect to the prison right. Now, when we talk about the right of a person, right in particular, rights in fact emanate even before the birth of a person. For example, if you can imagine the fetus, even before a person is born, like I know a particular girl who suffered from mental disability. She's a famous renowned singer. Her mother one day told me that, sir, my daughter is a mentally challenged. She is not in a position to understand the ground reality happening around her. As a result, why she should not be sterilized, which is called as hysterectomy, removal of the uterus in her body. Now, if a person is a differently able, especially of a mentally challenged, in 1971, the Mental Health Act says that even a mentally challenged person will have every right to enjoy like that of any other pretty ordinary individual. A person should not be discriminated. This we are talking about 50 years before, long ago, in 1971. Now, three courts, Canadian Supreme Court and UK, the House of Lords, as well as the Australian Court, got an occasion to examine this issue, but they came out with a different conclusion. In the Canadian Supreme Court said that because since these people are mentally challenged, normally they are appointed by the guardian. So the guardian takes a decision on behalf of the individual. Comparatively, the matter went to the Australian court. Australia got an occasion to examine and they said that even though they are guardian, even though they are the parents, as far as people with mentally challenged, since they do not have the act of cognition, cognitive thinking, that thinking process or decision making, because if you want to take any parts of your body to be removed, it should be done with your consent. The girl, in all the three identical cases, the girl seems to be of a mentally challenged, and their parent they came and said, But of course, they do not understand the difference between the procreation, contraception, or childbirth. Since they do not have the consciousness of their act, they said that in one of the cases, girl also became pregnant. So they said that pregnancy has to be terminated or aborted. Recently, I was handling a case in the Supreme Court. Justice Chandrachud bench had an occasion, the former Chief Justice. A girl was raped. She was a minor girl, and she became pregnant. As per the Medical Termination of Pregnancy Act, a girl has got every right to terminate the child if it is through unwanted or coercive sex. Now, when the girl wanted to terminate the pregnancy, if it crosses the limit fixed under the law, you can do it out of 52 months. We can do it within 24th to 25th month. After that, it is not possible. If you want to do that, unless it is involved for a therapeutic purpose and not for a non-therapeutic purpose, this pregnancy can't be done. So the judge got an occasion. They examined the medical report. The medical report said that if the fetus is terminated, it will lead to the danger of the mother. So the consent was sought by the judge with the girl itself as to whether she want to abort the child or retain the child. Now imagine the same situation happens to a mentally challenged girl. Because crime, the sin, the dastardly crime is being committed in our society mostly against the vulnerable, against the weak, particularly against the differently able. Now, the court said that even parents do not have a right to take decision upon the child. Even doctors, they do not have a right to take a decision. Why? Because that is the legal framework. Judges, in fact, they occupy a very central, pivotal position, which in law we call it as parens partia. Parens partia doctrine means the judges, they step into the position of a parent. So on behalf of the parent or on behalf of the state, the judges, they make a decision. So they said that if such a differently abled people, if they are aborted on such a ground, it will lead to the patent misuse. In the sense, the right to procreate, a right to have a childbirth, host of other rights will get affected. So why am I dwelling upon this aspect is that even a mentally challenged person, physically challenged person, or anybody in the world, they do have a right like that of any other individual. We cannot discriminate or eliminate a person only on the grounds of disability. The conundrum involved in the aspect of disability is very, very complicated because no individuals are alike in disability cases. The factum of disability will vary from person to person, and the degree of disability will vary from person to person, and their needs. In law, what we describe is the pertinent fact that you have to take the needs into consideration, and every individual will have their own needs and thinking. But in the society like India or a state like ours, we take the majoritarian into consideration and the minoritarian rights are often neglected. Now, when all this matter comes before the court of law, as I said, the judges, they have to make a collective a decision. A decision taken by the judge will have a greater impact for the posterity or the future generation to come. Now, judges are often in a dilemma because they do not have a proper understanding about the disability rights jurisprudence. For example, one case, I have handled several cases. One such case, a girl she aspired to be a doctor. She suffered from a disability called kyphoscoliosis. This kyphoscoliosis, her back, the curvature in the back spinal cord will be bent, is bent. As a result, she is not in a position to do any surgical procedure or incision. The Medical Council of India had a nugatory or arbitrary law in place at the first instance by saying that if you want to perform the surgical procedure incision, you should not have any defect or disability in your body. The question is not about the disability in your body. The question is disability in your mind. Because even if you take the normal doctors, we cannot assume or come to the conclusion, onerous conclusion, that the normal doctors are having every ability to perform the duty of a doctor just because they have taken the Hippocratic oath or they have studied medicine. What is required is that you need a human touch, you need a zeal, you need to understand the mind and the senses of a person, especially in diagnosing any disease. So, a patient can be cured not only by medicine. An ailing patient can be cured not by administering any pills or drug, only by way of a empathetic human touch, for which you need a proper understanding about medicine. That is the reason we engage all the people to study in a medical college. They are trained in such a process. But that training alone will not be sufficient because it is only a theoretical aspect. On a practical aspect, a person with a disability, as I said, they are facing a lot of hurdles, lot of challenges. This legal framework comes into the effective role because, for example, if a person is sick, he will become all right after a few days. If a medicine is administered by the doctor, you imagine the plight of a differently able person. He is sick, not mentally. Mentally they are very strong. Physically they are sick. This sickness this ordeal continues throughout their life. At the same time, if a person is born with a disability, the disability in nature, in 80% of the instances, it is progressive. It shifts from bad to worse. But in many cases, many instances, differently able people, disability can happen to any person. In war, in accident, or in modern days, because of cancer. A cancer patient is also a different able. If he is in the advanced stage, his multiple organ might get affected or crippled if he is not able to survive. So, what normally naturally happens to every person is a sort of restriction in their body. Now, to overcome the restriction, we need to have effective laws in place. That is why United Nations Convention talks about purposeful accommodation, employment. If you take the employment opportunity, equal employment opportunity commission in USA, equally we have that in India as well. Employment opportunities are not given to the differently able despite succeeding in their career. The reason is quite simple. As I said, these people are viewed as a recipient of charities rather than an object of an instrument of performing to the core. Even differently able, if you see, for example, if you take one instance, Satya Nadella, who was the CEO in Satya Nadella was the CEO in what? Microsoft. He had an autistic child. In his reference, recently his child passed away. He said, I became a great innovator. I became a great entrepreneur. I became a best CEO in Microsoft. The gratitude and the thanks is given only to my son. Because he says he is able to learn a lot of intricate, inquisitive things from his disability. That is why in all the private employment sector, they are able to progress because of the diversity and inclusion. People with a diversified background, it's most important pivotal that people with all stream of people, all types of different able people should be included in any system. If we exclude anybody, their views, their contentions, their aspirations are not taken or considered by the rest of the society. In fact, this lateral thinking of the that is why the cross functionality, that is intersectional thought, often infuses everyone to take a very conscious and a very better and equipping decision. If you take Albert Einstein, he says, life is nothing but riding a bicycle. To be successful in your life, you need to keep moving. You have to balance yourself. How will you balance? The balancing of competing interest in your life comes when you have self-assertion, aspiration, and lot of other positive traits and qualities. These positive traits and qualities can come in only when a legal platform provides an ample opportunity. Now, if you take Indian disability law, the disability law suffers from a lot of lacuna or defect. We are not able to grapple or match with the expectations of United Nations. This theoretical formula prescribed by the United Nations becomes a problem not only in India, throughout the globe. The reason is very simple. The laws are made only by the majority people. We don't consider the minority. Initially, when I refer to Judge Tattle, he says 10 years back, now his companion is a pet dog. This dog is able to guide him in all the pathways. For example, he says in his own autobiography, 10 years before, when he used to ride or walk on the street, he used to use a cane to navigate himself. But after the entry of his pet dog, the pet dog used to carry him, take him all the way, whether into the railway, wherever he travels. He says when he when he walks with the dog, the people they get enticed, and they used to talk to him, not because of his for this person, but because of the pet dog that he carries. Normally, he says nowadays everybody have become very cordial to me, and they used to ask me a question. Oh, you are carrying this dog. Very good. And how are you able to manage this? So many questions. He says lot of people have become my friends because of this pet dog. The pet dog has attracted a lot of friends, and even the strangers nowadays used to talk to him. So the lack of barrier communication, when a dog is able to integrate or integrate a person, we as a natural human sentience, human beings, we have failed in a miserable way in not protecting the rights of differently able. Differently able, for even though the statutes are written, to enforce the statute, every time they are forced to fight on the street. Not only fight on the street, they have to undergo a lot of battle by way of constant litigation. So, a lot of cases are filed in the court. If you see, to enforce the right, Ambedkar said that Article 32 of the Constitution says to enforcement of fundamental right itself is a fundamental right. So, if you do not have a remedy at the inception, the right becomes a nugatory one. So, the legal framework in any constitution or any global sphere, the written law should be put into effect. The law can be put into effect only when it is uniformly applied by all, applied by everyone.